Good morning. Today we are going to discuss about vicarious liability. So, what is vicarious liability? So, always in vicarious liability, whenever we are going to do any tort, we are held liable for the tort. But in vicarious liability, because of one person, the other person would be held liable. How it is? So, whenever a person commits an act which is unlawful, so that person is held liable for violating the law and thus he is punished accordingly. For example, A enters into the property of B without his permission. Such an act of A amounts to trespass and thus he is liable. So this is the general rule of tort, but in some situations, a person can be made liable even if he has not done any wrong, if it is done by some other person with whom he shares a certain relations. So, such as, for example, the master and servant or the principal and agent. And in these cases, this liability is called as vicarious liability. So, what is vicarious liability? So, vicarious liability means the liability of a person for an act committed by another person, and such liability arises due to the nature of the relationship between the two persons. So, for example, A is a driver who works for B, and while driving B's car for taking him to his office, so he hits C, a pedestrian. So, due to his negligence in driving, in such a case, even though B was not driving the car, he will be still liable for the accident which was caused due to the negligence of A. So the relationship we can see in vicarious liability. So under these relationships, yes, of course, we can see the person is said to be vicariously liable. So there should be a relationship as like master and servant, partners in a partnership firm, principal and agent, company and its directors, owners and independent contractors. So, vicarious liability of a master for torts by servants. So, in a master servant relationship, the master employs the services of the servant and he works on the command of master, and thus a special relationship exists between two. And in case of a tort committed by the servant, his master is also held liable. So there are many cases in which the servant does an act for his master. Thus, in law, it is deemed that the master was doing that act himself. So, therefore, if the servant commits an unlawful act, the master will also be held liable for the same. So, this liability of master is based on the following two maxims: Q facit per alium, facit per se. So it means that whenever a person gets something done by another person, then the person is viewed to be doing such an act himself. So if A is the owner of many trucks and employs a driver to drive them for the purpose of trade, and in case one of his driver gets into an accident, so because of his rash driving, then even though A did not drive the truck himself, he would be held liable for the accident. Then the second maxim is said to be a respondent superior. It means that superior should be always held liable for the acts done by his subordinates. So these two maxims have played a very significant role in the development of the law. of vicarious liability of the master. So, essentials of vicarious liability in master servant relationship. These essential conditions have to be followed for the vicarious liability of master to arise. So, the servant has committed an act which amounts to a tort. Such a tortious act is committed by the servant during the course of his employment under the master. So, the reasons for the liability of the master. There are several reasons behind holding the master liable for the acts of his servant, which are an act which is committed by the servant is considered to be done by the master through him, and therefore, in the law of torts, it is assumed that if any wrong is done by the servant, it has been committed by his master indirectly, and so the master is held liable for these wrongs. So the master is in a better financial position as compared to his servant, and thus, in case of any loss caused by a tortious act of the servant, so the master is the better suited to pay off the damages to the victim of the act. So also, since the master is made liable, he makes sure that all reasonable care and precautions are carried so that he can avoid such liability. So when a servant does any act, the benefit from such an act is enjoyed by the master, and thus for the liability arising out of the servant's act, the master should also shoulder that liability. So, the test for determining the master servant relationship. For the determination of a master servant relationship, certain tests have to be developed over a long period of time. So, we have a traditional view that is a control test. As per this test, for the determination of the master and servant relationship, it should be whether the master has the power to not only instruct what should be done, but also the manner of doing the act. And if such power exists, then as per this test, the master and servant relationship exists between the two people. So he is the owner of a big area of land on which the farming activities are carried out, and he has hired many workers for farming. We have a modern view. So the old control test is not applicable as an exhaustive test, because in cases of work requiring skills such as a doctor working in a hospital, the owner of the hospital cannot instruct the doctor on how to treat a patient and can only instruct him to treat patients. So thus, certain other tests have been developed for determining the master and servant relationship. So the test of work being an integral part of the business. In the case of Stevenson, Jordan and Harrison Limited versus McDonald and Evans 1952. So the test of an integral part of the business means a very important part of the business. Here, there is a contract of service was held to be a contract for such work which is an integral part of the business, and a contract for service was held to be a contract for such work which is not an integral part of the business. So in an IT company, illustration, and in an IT company, the programmers, as the employees of the company, there is a master servant relationship. But if the company has hired a catering service, the company does not have a master servant relationship, because the act of providing food is not an integral part of an IT company. So we have a multiple test. So this test provides that people who are in contract of service are deemed to be employees, whereas the people who are in contract for service are independent contractors. So in the case of ready mixed concrete versus Minister of Pensions and National Insurance, 1968, three conditions were laid down for a contract of service. So the servant agrees to provide his skill and work to the master for performing some service in exchange of for the wages or some other consideration. He agrees to be subjected to such a degree of control so as to make the person his master in performance of his work. So the other provisions of the contract are consistent with the same provisions of being a contract of service. So this view was reiterated in the case of the management of Indian Bank versus the presiding officer. So this test also includes other important factors that are used to determine the master-servant relationship, such as who owns the tools being used for work, whether the employee is paid wages monthly or on the daily basis, and all other relevant factors. So, thus, the old view of using the control test is no longer the only method of determining the relationship between the master and servant. So, as it has been realized that in the present complex world, where there are a wide number of factors which affect the process of determining the relationship between the employee and employer, it is not possible to use just one test, and thus the various aspects of the case are seen to determine the nature of relationship and to decide whether such a relationship is that of master and servant or not. Thank you.